With that, I'd like to introduce our speaker. Patina Park is the Director of Tribal and State Relations within the Office of the Minnesota Governor. And I will turn it over to you now.
Wonderful. Thanks, Sarah. Good morning, everyone, or good afternoon, I guess. I'm calling you from Pacific Standard Time right now, so I'm a little earlier. I'm really excited to be here with you and talk about the work that the state is doing around government to government relations. I would ask that if you have questions, please put them in the chat. I will try to save some time at the end to answer them or to answer any questions that people raise or comments even. We have an hour here, which is not a lot of time, but I still want it to be as get your questions if possible, or questions answered if possible. I am a Patina. I am Minkaju Lakota, so that means my family comes from Cheyenne River, which is over in what's now known as South Dakota. I also have family that are from Standing Rock, which is over there as well, just north of Cheyenne River. I, however, was raised by an Osage family from Oklahoma because I was placed for adoption at birth. I was born in 1970, and that was, during the time when Native children thought it would be better off if they placed them with white families. And so my mother was taken in the middle of the night to a place in Fargo, North Dakota from South Dakota. When she gave birth, they took her back in the middle of the night. And my family who adopted me, the adoption agency didn't realize that they were Native because they presented pretty much as white farmers to the agency. So I was blessed to have that connection at birth, and I was able to connect and find my roots over in my birth tribe about 12 years ago. But my story is pretty common, certainly not unusual. There's a lot of us out there who are still kind of making their ways back to their tribes. I have been here. The Office of Tribal State Relations in the governor's office has been here now for, well, 2 years. On March 9th was my first day when the project started. And I started 5 days before COVID hit. So really did change the dynamic of my job, but it also really helped to ensure that the tribes were connected and we're getting responses, and we're able to partner with the governor and lieutenant governor as the state responded to the crisis and rolled out everything from the test to the immunizations, et cetera. So moving on now, I do want to note here too, that you are the first group to see this PowerPoint that has our new kind of brand or our new logo on it. This was designed by Jonathan Thunder. He's an artist, an Ojibwe artist from the Red Lake Nation, and we are really grateful to Jonathan that he designed this for us. And we are also excited that we're able to start using these materials when we do presentations. Now I'm going to turn my camera off myself because it's weird watching myself speak. And so now we will get started. So government to government, what does that mean exactly, right? We have within the boundaries of the state that's called Minnesota, we actually have 12 separate governments that exist. We have the state of Minnesota, we have the 7 bands, Ojibwe tribes and bands, and then we also have the 4 Dakota tribes that are in the southern part of the state. Now, the state has been here, right? The Enabling Act was passed by Congress and approved in February of 1857. And then the state's constitution was approved on May 11th, 1858. Now, Minnesota has a little interesting history there in that our legislature started passing laws actually before Congress fully approved the Constitution. And so the Constitution that was approved in May was actually an amended Constitution that incorporated some of the laws that the legislature had passed in the meantime. And courts have left those laws alone. So it's important noting that all the tribes also have, in essence, their own enabling documents. So constitutions exist for them. You can go to their websites. You can also go on the Tribal State Relations page that MnDOT manages that has all of the tribes linked there. the Minnesota American Indian Chamber, or the Indian Affairs Council, has a website that also can link you to all of them. But it's interesting to read those constitutions to see when they were written, how they were updated, because they're all very different. And those constitutions, or those enabling documents for the tribe, are there for the federal government to recognize them as well as a federally recognized tribe. There are almost 600 federally recognized tribes in the United States. There's 574. All of those tribes have different varying documents of themselves, and most states don't have federally recognized tribes in them, believe it or not. California has well over 200, as does Alaska. And so those two states have the vast majority of the federally recognized tribal nations. But here in Minnesota, we have a good large number compared to other states as well. Now, when you think of government to government, I think we should start first for what is it? Because here at the state, of course, there's a lot of stakeholder engagement. We operate here on the benefit of the constituents, right? We're here to serve the people. And so the work we do to engage our stakeholders, to learn about their needs, to ensure that they're informed, that is not government to government. The tribes are not a stakeholder. It is also not part of the state's diversity, equity, and inclusion work. The tribes are a government. They're not a specialized group. Now, yes, they're Native American, and yes, American Indians suffer some of the worst disparities in the world, or here in the United States. Minnesota has some of the worst disparities across the country. And so it might feel like working with the tribes is part of that equity work and to ensure that we are meeting the needs of all Minnesotans. But there's actually two things going. So I'm not sure where you cut off from me. So just to kind of highlight government to government with Native people, there's the government, and then there's also the over 80% of Native American people who live off the reservation. 60% live within the urban areas, and the rest live in the counties surrounding the tribe. So there's also a lot of tribal people within the state who are not from the 11 sovereign nations. And so those governments don't speak for them either. Any more than, North Dakota would speak for Minnesotans, just because you're all within the United States, especially if you're the same racial group. Now, in the beginning, treaties are how the federal government interacted with the tribes. From Europe in the very beginning, 1722 was the first treaty between the colonies, between the Mohicans and the New York, Virginia, and Pennsylvania. And those treaties continued going on well until 1871, when Congress passed a law which banned all new treaties and did not recognize tribal governments actually at that point. Now, treaties are really important because they're also a recognition of tribes at a global scale of being a sovereign. And people sometimes wonder, why would the European countries have had treaties with the tribes? And then why did the United States take on that practice when it became a country? Well, one way to look at it is the United States, when they won the Revolutionary War and became a new baby country, knew that the larger, longer lasting governments, sovereign governments, had been recognizing tribes with treaties. And so by continuing that practice, the United States was putting themselves at the same level as England, Italy, those countries that had the treaties with tribes before the Revolutionary War. However, from the very beginning of the country until the late 1800s, there was a big shift from really recognizing the tribes as separate governments that you had to interact with, to being more of a dependent on the United States as it moved across. But specifically here to Minnesota, there were 16 different treaties between the federal government and the Dakota and the Ojibwe. And I encourage, if you haven't seen it, to go on the website Why Treaties Matter. There's also information on the Minnesota Historical Society. You can connect to that, because this really goes into detail about the treaties here within Minnesota. Um, as you can see, the tribes themselves gave up significant amount of land in order for the state of Minnesota to become the state, from being a territory into a state. And, those treaties are still in effect today. Most of the treaties that were signed by the federal government include language such as long as the water runs, as long as the sun rises, these words that make these treaties operate in perpetuity. This, from my opinion, is just a recognition that from the very beginning, the federal government did not see that tribal nations or separate sovereign nations of indigenous people would be around forever. And so it was easy for them to make these promises because they never intended on the indigenous people to remain. And so every single treaty that has been signed across the United States by the federal government with the tribes has been violated or broken in some way. And that is certainly true of the 16 treaties here within Minnesota. You probably should also, if you're interested in the history, is to dig into the Dakota experience. I don't have time here, but the Ojibwe and the Dakota had very different experiences with the state and with the United States as far as being here. Now, the Ojibwe came here a few hundred years ago. They migrated into these lands, but the Dakota, their creation stories are here. They were the original inhabitants, and there were other tribes even before that. But so there's a very unique, different experience from them that I encourage all of you to kind of dig into more, since we don't have time here. Now, tribal governments, are they sovereign? In the very beginning, when you look at the Trade and Intercourse Acts that were passed by the new United States of America, there was more of a recognition that tribes had full governance over their lands, and it was very separate from the states. That shifted as we moved along, and particularly in the 1820s to the 30s, when we got the Marshall Trilogy, that shifted considerably. Now, Justice Marshall of the Supreme Court here came out with 3 separate decisions within that, kind of 10-year period that really laid the groundwork and the bedrock of federal Indian law even today. And so the first case that he decided had to do with land. And in that decision, what he ultimately decided is that the United States government, when it won the Revolutionary War, obtained title from all of those other sovereign nations that had come here and kind of laid claim to the land, this doctrine of discovery. And so when the United States gained that title through war, the question remained, well, then what about the indigenous people who were always here? And so what Marshall distinguished is, well, by gaining title under this doctrine of discovery, what is left for the tribes is, well, the right to reside. And so the tribal nations and the indigenous people have a right to reside on the lands, but the United States owns the full title to the land. And so, we know what you can do, if you have a tenant. That sounds very much like a landlord-tenant situation of when you don't like your tenant, well, you evict them. And so the Indian Removal Act really was Congress serving eviction notice on the tribes there on the east side of the country. Now, many people will say, well, the Indian Removal Act forced the removal of the tribal nations, and that's not actually correct. What the Indian Removal Act did is it took the power to negotiate with the tribes from Congress and their agents and vested it into the executive branch. So the president now, who was President Jackson at this time, had the ability to negotiate with the tribes to have them move west of the Mississippi, where they would be free to be themselves in exchange for leaving their lands on the east side of the Mississippi for settlement. Now, there was a long period of time there where tribes didn't leave, right? It didn't force them to leave. What really was the impetus to that was we got the last two cases coming out of Marshall. And this was between the Cherokee and Georgia. They had some conflicts. Georgians were not happy that Cherokee were there. Georgia was not happy that Cherokee had a lot of gold in their land and they weren't fully utilizing it. Georgia was unhappy that Cherokee intermarried with, freed slaves, African slaves, as well as those who had run away. It was a safe haven. In the early days, the Cherokee participated in the slave trade, but they did free African people from slavery sooner than the United States. And so there's a lot of intermarriage going on. So, there were Black Indians, which for Georgia was very problematic. And then the other problem was, the Cherokee had a civilized, what was called at that time, government. Like they had a core government, they had doctors, lawyers, teachers, people who had gone to Europe to study and came back. So for practical purposes, the Cherokee looked a lot like the settlers in that they farmed, they had a structured government, they had courts. And that was also challenging to the Georgians. So Georgia decided that they would make it illegal for Cherokees to exist. President Jackson wasn't sending someone down to remove them. And so Cherokee took it, or the Georgians took it onto their own. They basically passed a bunch of laws that are very similar to the apartheid in South Africa. So it was basically illegal to be an Indian in Georgia. Now, the tribe had European trained lawyers. They had read the Constitution. They did not believe that Georgia had this authority. And so they filed a lawsuit directly into the Supreme Court, arguing that the Supreme Court had jurisdiction because they were a foreign nation. They're separate from the Constitution. There's no indication that the United States has included them. And so they argued that they were a foreign nation within the nation, which meant that Georgia had no authority. So the first case only had to do with jurisdiction, whether they counted as a foreign nation for the Supreme Court to even hear the case. Marshall determined they didn't. That because the treaty they had with the United States was a lot more paternalistic, promising care, protection, those kind of things, it didn't seem very government to government or equal government. And so Marshall called the Cherokee a quasi-sovereign, a domestic dependent on the United States, and therefore had no jurisdiction to hear this conflict between Georgia and the tribe. And so the case just went back. Well, at the same time, a missionary had gone into Cherokee and violated state law because he didn't get the permission of the governor before he went in to Cherokee lands. At that time, one of the laws they passed is any non-Cherokees had to have the express permit of the governor in order to travel into Cherokee lands. So when he stepped off, he was arrested, charged, and convicted of violating that law. And that case got appealed up to the Supreme Court, which did have jurisdiction now to hear this controversy. And ultimately, Marshall decided that tribes, because they're domestic dependent, but they're to the federal government because the treaties are with the federal government, because the federal government has the trust lands or owns the title. State law has no effect in Indian country. And so Georgia's laws were thrown out. Now, this seems like a big win for Indian country, but what it did is it sent a ripple effect across the country because now all the states who had tribes within their borders were thinking it would be anarchy. The tribes would not, had no one overseeing them. The state law couldn't apply. And so intense local pressure grew. And that is when tribes started to agree to move west of the Mississippi and give up their lands. Now, whether it was truly people with the authorization to sign or not, there's a lot of, whether the tribe themselves even signed these agreements, the United States military is what enforced them. And so that's where the forced removals came. They showed up in order to essentially escort the tribe out of their lands to their new lands and to ensure that they would leave. And so we hear the Trail of Tears and just, that a lot of Native people lost their lives during those forced removals over to the west side. Now, United States versus Kagma there in 1886 was a result of a case from 1880, the early 1880s that grew up. The Crow Dog, which is my favorite case ever, was just a situation where a Native person murdered another Native person on Indian land within the territories, the Dakota territories. The Supreme Court found that the territorial rule had no authority over that murder because it was purely a tribal issue. Congress responded to that, appalled that Indians could kill each other and no one would do anything about it, and passed the Major Crimes Act, which made murder, kidnapping, these high-level crimes illegal within these federal lands. And Kagma was the case that challenged whether the Major Crimes Act was valid. And the United States Supreme Court found that yes, the Congress has the power to pass this. Now, Iron Crow versus Oglala in 1956 is a case that combined two that related to taxes and adultery, where two tribal members, one committed adultery in violation of the tribal law, and another non-Native person was not paying the taxes that were the tribe was saying that were due. And so while living on the reservation, these cases went to the Supreme Court and they found that yes, actually, the tribes still retain their inherent sovereignty, except if Congress has taken it or it's been taken in treaty. So this is where this inherent sovereignty concept comes from, that tribes have sovereignty unless you can find a place where they have given it up. So now we're in a much stronger quasi-sovereign position than we were during this kind of domestic dependency state with Marshall. And so now we do have this federal trust responsibility that exists with the federal government and the tribes. It's legally enforceable. I would say the Cobell settlement, if you've heard of the Cobell litigation around trust resources and the United States failing to uphold them, was probably the largest case that was just about a violation of this general trust. But the federal government is supposed to be protecting the treaty rights that are in each of the treaties, the lands, the resources, assets, the people that exist within Indian country under this trust responsibility. And that trust responsibility was in exchange, right, for all of the land which the United States sits on. And so it's not, some people look at this as kind of a, again, a paternalistic, like I need to care for the trustee because they're unable to care for themselves. But in this federal context, it's really more to do with the fact that, all the land within the United States was at one point tribal. And so as the United States has taken this land and made treaties or other agreements with the tribes over it, they have created this trust responsibility now towards the tribes. And that was made permanent by congressional law during the Indian Reorganization era in the 1930s. And so this government to government recognition means that the federal government meets with the tribes, consults with the tribes, sees them as another government that they interact with. And there's an entire renewal going on at the federal level right now around updating consultation policies, ensuring that tribes are having a stronger voice. And I would say a lot of that probably has to do with the fact that the Secretary of the Interior now is a Native woman. Secretary Helland is from the Southwest. So that has really increased this kind of ability for the federal government to start engaging with tribes again at a government level. The trust responsibility they have, though, is challenging because they have a trust that exists in other place. And so there might be controversy over a national park where they have a trust responsibility through the National Park Service when a tribe is saying that things going on in that park is affecting their trust resources. So the federal government can often be stuck on both sides of the issue, but the Supreme Court has found multiple times that they should be able to manage it. That they have to manage it. And so one trust does not raise higher than another. They have to figure out how to work them out together. So that kind of turns here then, well, if the federal relationship is with the tribes, then why does Minnesota have a government to government relationship with the tribes as well? Well, here in Minnesota, with the 11 sovereign nations, the Constitution has vested the legislative branch with plenary power over Indian affairs at a congressional level. So the state does not have authority over a tribal government unless expressly authorized by Congress, right? This is why during the COVID executive orders, if you noticed, a lot of them had a little part in it that made a comment that the governor did not have authority over the tribal nations or their lands or business, and recognized that sovereignty that they had. So, for instance, the governor could not have issued an executive order shutting down the tribal businesses. The state legislature could not have passed laws that made the tribal businesses have to close, right? The tribes have sovereignty over that. And so these federally recognized tribes are not subordinate to the states. Actually, if you look at kind of this hierarchy of jurisdiction or sovereignty, if the federal government is on top and then the states are on the bottom, the tribes fill in the space in between. Sometimes they're closer to the state. Now, there's a lot of tax laws and other federal laws that will say expressly that tribes will be treated like states. But in other areas, they pop closer to the federal government, where they clearly have more sovereignty and jurisdiction ability than the state governments have. There are only very few times when the state jurisdiction and sovereignty will pop above the tribes. And often that is through things the tribes sign. If the tribe signs an agreement with the state in exchange for something, and they agree to do something for the state, they have become now a grantee, a contract, of the state. And so tribes are very careful in modern eras about what they sign and ensuring that their sovereign immunity, that other sovereignty elements remain in those contracts, and they're not treated just like another nonprofit. For instance, if they are, going for grant funding for education or, victim services or policing, et cetera. So the tribes too have the sovereignty to regulate their own activities. So they have their resolutions, they have their laws that apply to their community and to those who come in to their community. Civil laws have authority over everyone within Indian country, but tribes do not have criminal jurisdiction over non-native people within their tribes. This is challenging, of course, because if the state or the federal government aren't enforcing laws, and this tribe has no authority over non-native perpetrators or criminals, a lot of crime can go unpunished and undealt with within Indian country. And this is, why the murdered and missing Indigenous relatives movement has become like more in the consciousness of people. The situation leading to that is just there's so much non-enforcement and cases that go unaddressed in Indian country over violence and murder. So what the tribes will do is maybe have an MOU, have an agreement. Prairie Island in 2019, I believe the law passed, actually has an agreement of recognition by the state that their law enforcement can enforce state laws on their reservation against non-Indians who commits the crime. Basically, their law enforcement are dual recognized as both state and tribal, so that they can enforce both tribal law and state law, depending on who the defendant is in the situation. And it may not just be around law enforcement. It could, there also might be things around environmental protection. Maybe the tribes are the ones doing the environmental review on issues and that the state is working on. Perhaps it's even MOUs and relationships around child welfare practices on how they will interact for ICWA cases or et cetera. So the tribes kind of can collaborate, can partner and contract with the state, compact, with the state in ways that the counties and cities can't. And the other kind of interesting thing about all this is because the tribes are closer to the federal government, but are not named expressly within the kind of the enabling documents of the federal government. There's an argument that should the federal government collapse, if the United States were to collapse for some reason, the states would not immediately become independent, recognized sovereigns because they're part of the collective, right? It's the United States of America. They would have to do some work to get recognized at a global scale, whereas the tribes are recognized as separate sovereigns, both at international law as well as in the United States law. So there's an argument that those tribes governments would still remain and be the only governments left within the lands if the United States were to collapse. They would not collapse with the United States. Now, it's worth noting here too, in Minnesota, we are a public law 280 state. And what that means is in the 50s, Congress, who has the ability to take away some of the sovereignty of the tribes, passed a law that gave states jurisdiction within Indian country. So Minnesota and Wisconsin are both public law 280 states. Here in Nevada, we're a public law 280 state where I'm sitting now. And so now the state has authority to go into Indian country and enforce their own laws. Prior to Public Law 280, the state couldn't. There was like a wall at the border. In Minnesota, the difference is Red Lake in the northwest part of the state, they went to Congress and essentially waived out of Public Law 280. And so they are what's called a closed reservation. So state law does not apply in Red Lake. It applies in the other 10 tribes. It does not apply at Red Lake. So they have tribal jurisdiction and federal jurisdiction there only. So here in Minnesota, what does it look like to collaborate and cooperate with the states for the tribes? Well, you know, we just have to acknowledge there's a very long and painful history here in the state of Minnesota. For a very long time, there has not been any kind of historic recognition of the sovereignty of the tribe or even respect. There's been a lot of controversies that go back and exist even now. And a lot of this too is because over the country, there's not a good understanding of who Indigenous people are, who tribal governments are. And so, you know, racism bias still exists throughout the state, and in some areas higher than in others. So how we engage with the tribes for a long time here has been done through executive order. So the governor would come in, issue an executive order that would state how the state is going to interact with the tribes. Pop quiz here though, who was the first governor who signed an executive order recognizing the relationship with the tribes? Did any of you guess that was Governor Jesse Ventura? Executive Order 2-10 in October of 2002. It was not as expansive as now, but it was that first recognition of a government to government relationship. And ever since then, every governor has done it. Governor Pawlenty did it. I could not find any pictures online though of the governor with any of the tribal nations. And for those of you who are around, there was a lot of controversy between the tribes and Governor Pawlenty, so that's not surprising to me at all. Governor Dayton signed it in August of 2013. And then when Governor Walz stepped into office, he also issued Executive Order 1924 in April of 2019. And as you can see here, all the tribal nations showed up. They had an official signing of the Executive Order down in the Lower Sioux community with President Larson and the rest of the tribes. And it was celebrated by the tribes because they had a role in what was in there, what was included. The Governor Wassel, Lieutenant Governor, reached out to the tribes to see what was missing in the earlier executive orders so that they could put them in to theirs. So Executive Order 1924 recognizes first obligation to consult annually. Policies are to be developed in each agency on how we're going to have the government to government relationship and consultation, and those are submitted to the governor's office. As we're thinking of legislative proposals from the agencies, they are to consult annually with the tribes about those initiatives so that they can be included within the legislative proposals from the agencies. And then, of course, tribal liaisons now, someone has to be assigned that role in all of the agencies. Prior to that, the earlier executive orders really only listed those agencies that had a high level of interaction with the tribes. And then they also required all of the commissioners, deputy commissioners, tribal liaisons, and staff who are interacting with the tribes to attend the tribal state relations training, which is a in-person 2-day training that is offered through MnDOT and their tribal state relations training team. Now they do them online over, I think it's 5 sessions over the months, and are hoping to go back to live version. But this is a training that was put together with the input of the tribes, and is really I would say it's what they want the agencies to know about them and know about how all of this should be working. Now, Executive Order 1924 was rescinded, however, because we were able to get a law passed to codify it. But prior to that, as they started doing this work, Lieutenant Governor Flanagan recognized that there really needed to be some kind of direction, some kind of support at the governor's level to really highlight the issues of the tribes, as well as to work with the agencies and support them in their interactions with the tribe. And so the Bush Foundation funded 2 staff, myself and then another person, to come in to the governor's office and focus on that work. So the Tribal State Relations, the TSR team here in the governor started in March 2 years ago and have been doing this work ever since. We, once COVID hit and we all started working from home, right? We, at the end of March, set up daily meetings through the week with the tribal leaders and the lieutenant governor so that, we could be sure the information was getting them. They were raising their challenges. For instance, this is where information around who is going to be their emergency, person to connect with our emergency people around the FEMA issues, FEMA reimbursement, et cetera. But it really helped to have this kind of space where challenges that they were experiencing as well as successes could be shared. And, at one point, the Commissioner of Deed, we visited the Shakopee Nation and their casino to see how they had opened and opened safely. Back when they were trying to come up with the guidance for businesses across the state on how they could be effective. I don't think it is surprising that there were no large surges that came from the casinos because they were reopened, very focused on keeping people safe. And following the guidance that had been given by the CDC as well as the Department of Health. Now, those meetings, we continue now, but we're weekly. So every Thursday afternoon at 4:00, we have a meeting with tribal leaders as well as their staff. The commissioners now have been invited, all the tribal liaisons, and this becomes an avenue for people to share information. The Commissioner of Health, Commissioner Malcolm, will come in about every month, every 6 weeks to give updates about COVID. But it really helps to kind of create this ongoing communication so that the tribes have a place that they can raise issues to be addressed quickly, rather than trying to go up through the agency or, previously to this administration, it took a long time. If not if ever, if only the Mayak meetings is where they would really be able to give kind of highlight their concerns, and those were only quarterly, which is not enough. And so the Mayak meetings now meet still quarterly and have a collective presence of all the tribes. And then we have our weekly meeting as updates, as well as we have continually scheduled one-on-one meetings between the tribal nations and Governor Wass and Lieutenant Governor Flanagan. Now, as I mentioned, we did pass state law last year that codified the government to government relationship. Minnesota is the first state in the country to pass a state law that recognizes this requirement, as well as the obligation to consult with the tribes as the agencies are developing policy. Now, what's also special, I think, about this state law is it came out of a work group that consisted of tribal lawyers, lobbyists, other people that the tribes appointed. And we met weekly with them, the TSR team, to talk about what was needed, to kind of talk through what was missing in the executive order and what wasn't working in the executive order. The tribal liaisons from each of the agencies provided input and review. And so it was very important for the governor and lieutenant governor that this process was tribally driven legislation that was supported by them, but not led by their office. And so when it was passed and became law in July of last year, and it's now referred to as 1065 because that's the section that it is now, and the ceremonial signing was held on November 8th at the state capitol. It was actually over in a larger building, room in another building, but the tribes were there. It was exciting to see the signing take place. And, we've heard from many of the tribal leaders that this administration and this governor and lieutenant governor are the best, or have the most interaction and positive interaction that they've ever had. And, the governor and lieutenant governor feel very strongly that when the tribes are strong, when their tribal communities are strong, then the whole state is stronger for it. So they see them as a partner. And so from, our office, some of the things that we encourage the agencies, as well as just, I would say across the country, if you're going to work with tribes at a federal level or even at state level, there are some principles that you should consider and incorporate. I think the first one there of understanding the history is one of the most important. If you are working with tribes and never had the time or taken the time to really learn about the history within Minnesota or even across the country, you're not going to be able to interact or really have good understanding and respect for what the tribe has kind of gone through and the conditions that they're dealing with now. That history has a huge role in driving why Native people have such high inequities here within the state of Minnesota and across the country, right? That kind of historical experience has compounded on top of each other in a way that, housing, mental health, chemical health, physical health, all of these things are directly impacted. And that impacts the tribal government, right? So you have to understand that history to be able to apply it into the modern time. It's also really important to respect the tribes as sovereigns, right? They're not a special interest group. They are not just a Native special interest group. Their race, actually, and cultural identity is irrelevant to the government relation. It is more about applying more of a diplomacy kind of lens than it is any kind of diversity work like I talked about earlier. Tribes have self-determination, they have self-governance, and you have to understand that and appreciate that if you're going to interact with them. They don't want you to come and rescue. You don't need to come at them as this, kind of assuming you know more, that you're there to help. They might surprise you in helping you or knowing more about the issue than you do and actually be giving the guidance. And then also, if we're going to engage with tribes at a consultation level, right, understanding it's an entire process. And it's not lineal, it's a circular kind of process, because you need to start at the earliest stage, but then as you move through each phase of whatever you're doing, you're continually having these engagements with the tribe to let them know. It's not just a one stop, let me get your input, okay, thanks, and then they never hear from you again. That is not good government to government relations. You do also have to respect that tribal cultures are unique. Each of the 11 separate nations within the state, though they're Ojibwe, Anishinaabe, and Dakota, are different. There are 11 separate different tribes. And each of the 574 federally recognized tribes are separate, independent, and unique. And so, recognize those differences, learn about them, learn what makes those differences, because that will also improve the ability to interact and to work with them. Know who you're consulting with is important, because a lot of tribes will complain that they'll meet with an agency, and this is at a federal level too, and they all come to what they think is an agreement. And then the state staff or federal staff say, okay, well, let me take this back to my superiors and see what they think, and I'll get back to you. That wasn't true government to government, right? That was government to another government staff. The decision makers, the officials need to be in those meetings. And, when the tribal chair is in the space, that's at the same level as the governor, or quite frankly, the president of the United States. They are the leader of a sovereign nation and its citizenship. So recognizing that and really respecting it is important. Coordinating so that they're not getting hit with a multitude of consultations. I mean, tribes and agencies could consult every single day, all day, on everything that the agencies do. So knowing what's important, what's going to have substantial impact on the tribe as a government. And then removing any kind of impediments that might exist for full tribal participation. Here in a Zoom world, it makes it a lot easier. But once we go to in-person meetings and that becomes the norm, are there, scheduling a consultation or meeting with, the White Earth Nation in the peak of, February, when winter has shut them down? Not smart, right? Scheduling at a time when they are available is, and you have to know about them in order to do that. So, but overall, right, the government to government relationship with the tribes in the state of Minnesota and across the country, if other states incorporate these principles, can only lead to a stronger state, because, each of the tribes within their regions are one of the highest economic drivers of that region. They are employing non-native people who live in the area, providing benefits, providing support. And so, recognizing them as a partner rather than in this kind of deficit idea of them, needing support and help all the time is also so important. Recognizing the kind of the modern presence of these tribal nations so that we can have good relations. And so I'm now at the end. I apologize again for, oh my goodness, the problems with technology. So we don't have much time. So if anyone has any questions or comments, now would be your time. Yeah, and I think, to Daniel's point, that would be a fascinating CLE, because it's a very complicated area of civil jurisdiction within Indian country, and how everything applies to them. But if a non-tribal member is employed by a company on tribal lands, there's a very good chance, if it's on tribal lands, that company has an agreement with the tribe. And yeah, the employee would need to know that, to your kind of example. All right, well, I do want to thank you all, Plamia, which is Lakota, for thank you for joining us today. I apologize for the technology problems. If you have any other questions or comments, please reach out to me. That's my cell phone. You can text me. You'll get a faster response than if you email me, because my email box is obnoxious. But, anytime you have a question, reach out. Also, if you're around the governor's office, reach out, see if we're around. We'd love to meet you. I hope you all have a great rest of your week. As spring is coming, the birds are singing, right? Well, yes, get more snow, but it'll melt. And pretty soon we'll be complaining about it being too hot and humid. So everyone take care. Stay safe